10 seconds, 5 seconds. Start. This appeal inter alia impugns the order of the learned single judge passed on 28 February 2003 dismissing IA number 116 of 2002 in suit number 604 of 2000. The appellant in that application had prayed that the copies of the plaint and other documents were not supplied to the defendants and time to file application for leave to defend be extended. Mr. Kataria, learned counsel appearing for the appellant, has contended that nowhere on record has it been mentioned that copies of the plaint and documents have been supplied to the appellant and therefore there was non-compliance of Rule 3 of Order 37 of the CPC. In a suit to which this order applies, the plaintiff shall together with the summons under Rule 2 serve on the defendant a copy of the plaint and annexures thereto, and the defendant may at any time within 10 days of such service enter an appearance either in person or by pleader, and either case he shall file in court an address for service of notices on him. On the basis of aforesaid, Mr. Kataria has contended that it was mandatory on the part of the respondent to have served on the appellant a copy of the plaint and annexures thereto, and as from the record it is apparent that the plaint and annexures were not supplied to the appellant. The mandatory provision of rule was not complied with, and therefore the period to file application for leave to defend application cannot be counted from that date. On the other hand, learned counsel for the respondent has contended that the appellant had put in appearance but did not raise the issue of non-supply of the copies of plaint and annexure in any of the proceedings after 24th April 2002. In the said order, the learned single judge has recorded that the defendants have moved the application for supply of the copies of the documents which are not annexed with the summons of the suit, although he has entered appearance as a matter of precaution. On that date, the learned single judge directed that copies of the documents be furnished within 1 week. The later part of the order is important, which reads as follows. However, this would not be treated as an excuse for late filing of the leave to defend application in case the summons for judgment are served on the defendant. On the basis of the aforesaid, it was contended by Mr. Chabra, learned counsel appearing for the respondent, that once the appellant has entered into appearance and summons for judgment in appropriate form was served upon him, the court has no power to extend the time to file application for leave to defend. We have given our careful consideration to the arguments advanced by the learned counsel for both the parties. The short controversy is with regard to whether compliance of Rule 3, Order 37 CPC was done by the respondent or not.